Think your estate is too small to worry about planning? Think again. You might still need to take action, or your loved ones could face delays, stress, or even court. I'm Elijah Keys, certified estate planning attorney. That means I'm board certified, like a doctor is board certified, except in estate planning. I've done more than 3,000 trusts and post-death transfers. I'm here to talk to you about one specific type of transfer called an affidavit, sworn statement. You're going to want to stay to the end because there's some information in the very last section that's really important to know. In California, there's a simplified way to transfer certain types of assets. And I'm just going to list them, okay? Number one is a vehicle, like a car, a boat, a truck. Number two is a mobile home. And number three is an account or other type of non-real estate asset that is less than $206,000. And why do we use that number? We use these specific things because the law has said that judges are in charge of really important things, but we don't want everything to go in front of a judge. A probate court generally does not need to see something which is a small enough value. And so these specific three categories of items, a vehicle, a mobile home, an asset worth less than $206,000. Judges don't need to see those. So let's talk about how that works. This only works if there's no probate. So if there's a $2 million house in somebody's name and the court has to see it, all these rules are off. Every single one of these affidavits or sworn statement transfers can only be done if there's no probate involved. So if there's a probate involved in another state, a probate with another piece of real estate, a probate caused for any other reason, every single one of these statements no longer counts. All the assets go through the probate court. Even when the estate seems modest, no house, a car, a few bank accounts, your loved ones might still deal with delays. Legal red tape unless you plan ahead. Good news is California has a shortcut for these assets. If the total probate assets are under $206,000, or it's cars or mobile homes, your family might be able to skip probate altogether. In this video, I'll explain what an affidavit transfer is, how it works, walk you through an example using our fictional family, James, Laura, and their kids. Now, this is part of our video series about post-death transfers. There are 4 or 5 other videos already filmed in this series. If you're here and you haven't seen those, go back and watch the main video, which walks you through the basics of the 5 different types of transfers. So what is a small estate transfer? In California, there's a legal process to transfer something called a small estate. This isn't small. It's less than $206,000. Now, I would love it if someone gave me that much money. If you have it, send it. I'd love it. Except that this isn't really a small amount. What it simply means is that the law has decided that it's not important enough to deal with a judge. You can deal with it privately. If the assets that you have are less than that amount, you do not need a probate court. This is under California Probate Code 13100. Doesn't really mean anything except that's the law that allows it. And it allows you to transfer something without going through a full probate process, but only if the value of all your assets that transfer under this specific thing, this code, are less than $206,000. So let's talk about some ways that it doesn't work. It doesn't work if you have a piece of real estate that's over a certain value. It doesn't work. It doesn't work if there's a probate court. It doesn't work if your bank account is $207,000. It doesn't work. So the common way that this is used is to prepare what's called a small estate affidavit. An affidavit is a sworn statement under penalty of perjury. If you want to prepare one yourself, you read the law and you figure out that there's 5 requirements to that law. Number 1 requirement, the person's dead. Yeah, you can't take somebody's account if they're not dead. If you do, it's called theft. Please don't do that. Number 2, they have to be dead for at least 40 days. Doesn't work the day after. If you're going to the bank saying somebody died, give me their account, it doesn't work. You need 40 days. Number 3, you need a certified death certificate. Number 4, you promise, and you are the one that's preparing this, you promise, I'm going to say it again, you promise, under penalty of the law, that you are the one who's supposed to receive the asset. And number 5, you promise that if you receive the money that you will pay their debts. You don't just get in and walk away. If somebody who's a creditor comes forward, let's say that somebody owes $2,000 in medical bills and you received a $2,000 account, then the creditor gets to come forward and say, give me that $2,000. They get to ask for the money, so you promise to pay it back if creditors come forward. Okay, it's really important to know that. The second type of transfer is for a car or vehicle. Now, of course, this doesn't work if it's a jointly held car. For example, my car is in my name and my wife's name. So obviously this wouldn't be the small estate transfer because it's already transferred through joint ownership. The third type of asset that's transferred here is a mobile home. And this is a little bit different because mobile homes have property tax issues. And so mobile home transfers are more complicated than the first two. Later in this video, I'm going to explain the specific way that you do these transfers, so you're going to want to follow along because this one gets weird. So let's follow along with James and Laura's example. James passes away unexpectedly. Laura's really sad. She's his wife. He had a used car worth $15,000. He had a bank account worth $5,000. He had a few items of personal property, tools, electronics, maybe some collectibles. He didn't own a home. He didn't have a trust. He didn't name beneficiaries.
Now, because his total probate assets are under $206,000,
He had the $5,000 bank account. And the car is worth less than $15,000. Laura and his adult children can use the affidavit procedure for both of those assets. They are separate. The car doesn't add to the bank account value. The bank account isn't considered a car. They are separate procedures. They'll have to wait for 40 days after James' death, fill out the right affidavit with the right legal language, have it notarized often, present it to the right bank or financial institution. For a small estate, they're going to use an affidavit under Probate Code 13100. For the car in California, they use a form at the DMV called Form 5. Now, something to note here is that the DMV has changed their processes and their procedures many, many times. And so if you go to the DMV, you say, but Elijah said this. It's actually not what we do to our customers. When our clients have a car to transfer, we give them a set of instructions, which includes go to the DMV and ask them how they want to transfer it. When you're speaking to the DMV agent, we don't know which method of training that DMV agent received directions for. We don't know if they want directions that are current. We don't know if they want the last stage. We don't know if they got the directions that were 20 years ago. Each one of those are different sets of directions. To my count, there are 4 different sets for my understanding. Each one of them still works. The clerk that you talk to there might not know the most current form. So please don't go into the DMV and yell at people. They work hard enough. But at the same time, understand that they can help you. So they want to help you, but you have to be prepared. You have to bring the original title, you have to bring the will, if there is one, and you have to bring a certified death certificate. Go to the DMV, ask them what forms they need you to use, okay? Easiest way. The mobile home is different. We're going to talk about that later. It gets weird.
what counts towards the limit of $206,000?
Well, this is where people get really tripped up. It doesn't include a joint bank account, like joint title, doesn't include assets in a trust, doesn't include a life insurance or retirement account with a named beneficiary, it doesn't include a pay on death or a transfer on death account, it doesn't include real estate, it doesn't include a car, it doesn't include a mobile home, it doesn't include a boat. What doesn't include? It includes bank accounts that are only in the deceased person's name. It includes personal property without titles, without named beneficiaries. It includes collectibles, jewelry, furniture, electronics. It also includes digital assets like Bitcoin or credit on a virtual website. We have to deal with those at a different time because there's a completely different process to transfer those. By the way, those of you that have Bitcoin, you are in for a very, very hard experience. We're going to do a different video on that. I'm speaking to the entire state bar about that. It's hard to transfer Bitcoin. To my count, there are currently 9 former FBI agents who found Bitcoin, stole it, got arrested, and are currently in jail. So if FBI agents can steal it, somebody else can steal it too. Be very careful with Bitcoin. So in James's case, if there's the $15,000 car that was only in his name, not part of a trust, that counts towards the probate total value. The same goes for the bank account and anything else he owned outright. But remember that he only had $10,000 of assets that were appraised. $10,000, he had a $5,000 bank account, $15,000 car, that transfers. So how do you actually transfer this? Well, to use this simplified process, here's what you need for every single thing. Every single type of asset that you have. We have the mobile home, we have the car, we have the bank account. Let's describe each one differently, but let's say how they're similar. They're all similar because there's a law that allows the transfer. The law that allows the mobile home transfer is not in the probate code. It's different, okay? But here's the requirements. They're all the same. The requirement is that you must submit some sort of form to the organization that controls the title. That is, whose name is on the record is the title. The organization that controls the registry for that item. With a bank, it's of course the bank. With a bank account, it's the bank. With a boat, it's the DMV, sometimes the Coast Guard, if it's more than 30 feet. If it's a mobile home, it's going to be California Department of Housing and Community Development. You have to submit the required form affidavit. The DMV has a form. The Department of Housing and Community Development has 3 sets of forms, so this is where it gets weird. And the form for a bank account is under Probate Code 13100, and they all have some similar features. Number 1, the individual has to be dead. You cannot take a living person's car. It's called theft. And number 2, they have to be dead for at least 40 days. That doesn't mean 39. That doesn't mean 1. means 40 days. Number 3, you must have a certified copy of the death certificate. A non-original doesn't work. It must be certified. You get those from either the recorder's office or the mortuary, whichever one that you have. Number 4, you must have a claim to this asset. You must be the beneficiary under a will. So you have to show that you are the person who should get this asset. Number 5, you have to promise that when you get the thing, when you get the car, when you get the bank account, when you get the mobile home, that you promise to pay the debts of the person who died. And it's really important that you know that. Because if you receive a $5,000 bank account and there's $5,000 of medical bills which are valid, you can't just say, you don't have to pay. You promised to pay. And if you don't, they get to sue you. Because what they do is they go to the bank and they say, hey, this person owed me $5,000. And the bank says, I don't have the money anymore. Here's the affidavit. Joe Schmo down there, Ashley said that he would promise to pay you. See, it says number 5 right there. They promised to pay under penalty of perjury. That means you promise you're not lying. And then the creditor comes to you and they say, hey, you promised not to pay. And you say, I'm not going to pay. Then they get to sue you because you promised to pay. If they sue you, then you get to pay all of their lawyer's fees. And I can tell you that lawyers are more expensive than $5,000. You might as well just pay. So if you receive those assets, you want to hold them for a period of time before you actually spend them, because if you spend them, you still owe it. It doesn't matter if you invested the money into your best friend's restaurant and he can't pay you back. You paid it, you have to pay it again. That's how it works. The final requirement is that there is no other probate happening. So if you know that there's a probate, for example, in Ohio, then you can't do that. The probate court is in charge, even if it's in another state. If you have a California probate, you definitely can't do that. You also can't do it if you know that there's a probate coming. So if you know that you're going to have to file probate for something else, you can't run to the bank and say, give me this money. You are promising that there is no other probate. Now, will anybody ever find out about it? Maybe not. But if they do find out about it and you are the person that took the money, you can bet your butt that you are in big, big trouble. Because remember that if you lie on the form, you have to pay everybody else's legal fees to fix it. And I tell you that lawyers are pretty expensive. So what are the limitations? Here's the fine print. It only works, again, if there's no real estate involved. There is a code to transfer less than $50,000 of real estate, and a different code which just was passed to transfer $750,000 of real estate. But it doesn't work if there's real estate that's going through a probate. It only works if all heirs agree and there's no conflict. If somebody says the will isn't valid, then you can't use that will. They have to have the opportunity to challenge it. It only works if the assets are easily identifiable, if they're accessible. If you know that there's a bank account but you don't know what bank it's at, there's a lot of banks. And you would have to go to each individual one, or you have to hire some sort of a private investigator. I always encourage my customers to write down their assets. So if you haven't done so, secret hint from me, write down everything that you own on one sheet of paper. Make sure that it's stored in a convenient place, not in your safe deposit box. And make sure that it's stored in a place that people will look. Don't put it in your basement, in a box, under the dryer, that is only found when there's a flood. Real story, don't do that. So if James had unknown debts, there were disagreements among the heirs, there's a relative that contested his will or his distribution, this shortcut won't help. The court would likely have to get involved in that case. So I promised you that we would talk about this weird transfer of mobile homes, and I will. Mobile homes have 3 different ways that they're taxed for property taxes. You can pay property tax on the mobile home, you can pay property tax on the land, you can pay property tax on a combination of the 2. And there's a different set of forms for each one. Now, what do you need to transfer a mobile home? You need 2 different things in addition to everything that we've talked about here. You need the registration card and their certificate of title. Each mobile home has a registration card, very similar to a car has a registration card. And the mobile home also has a certificate of title, very similar to a certificate of title for a car. If you're going to transfer a car, you need to use the certificate because cars transfer by the certificate. If you have a mobile home, you need to transfer it by the certificate. It's the title. But how do you do that? Well, you need to surrender the title to the person who's going to get it with this affidavit. So the owner, the title should be under the owner's name, who's now dead, and you file the correct forms with the California Department of Housing and Community Development, and they will either take the original title and reissue it to you, or if you can't find the title, you have to fill out a couple more forms so that they will provide a replacement title and then provide you the new one. So it's really important that you follow all those rules, because otherwise what happens is you go into this kind of administrative quagmire. You send them documents, they send it back with a few notes that you don't understand. You look it up online, you find the right thing, you send it back, they find another error, they send it back with the second error with a few additional notes. And you say, why didn't they tell me the first time? And the answer is because they just want it off their desk. This is a person who's working just like everybody else. And they're not going to go through your entire file asking you to fix every individual thing unless they feel that it's important to do so. You have to know that this is a difficult process, and you can either try to get it right the first time, and if you don't, just understand that there's likely to be 3 or 4 back and forths, because if you didn't do the first part of the form right, you probably didn't do the second part of the form right, probably not the third or the fourth. And so if you're doing this form, easiest way to do this, find a sample online or just call them. How do you plan beyond this point though?
What if your estate is over $206,000?
What if you own real estate or just a small condo or a vacant lot? Well, probate is required unless you have a trust or other estate planning tools in place. Also remember that just because you can use the small estate process doesn't mean that you should skip planning. Even small estates can create stress, confusion, or disagreements if there's no clear roadmap. You can still create an estate plan even though you can use a small estate affidavit. I do it all the time. Now I want to distinguish one new procedure which is available for real estate. It's not the small estate procedure. This procedure was enacted April 1st, 2025, so it's less than 45 days old. However, something to know is that if you have a piece of real estate in California that does not automatically transfer, and that real estate is worth less than $750,000, you can do a court petition with the probate court. A petition basically means a certain type of motion or lawsuit. You can file it in the probate court and ask the court to determine who that real estate should transfer to. The court is going to issue an order to determine heirs or determine beneficiaries. So the court is going to decide who gets that house, and then the house transfers. That's a non-probate transfer, but that's very new. Very few people have done that. There's a final procedure to transfer a piece of real estate that's worth less than $50,000. I've only used it twice, and I've done more than 3,000 cases, so just so you know, it's not common. If you want to look it up and go through that quagmire, it's probate code 13050. I promise that's the last law that I'll quote to you today. I've only used it twice. It's very rare. So just to wrap up here, small estate transfers are a great tool, but they're not a replacement for good planning. They can be part of good planning, but they have to be used in conjunction with your overall plan. If you want to make things easier for the people that you love, no matter how big or small your estate is, take time now to create a plan. It's one of the most caring things you can possibly do for your family. Finally, if you have experienced the death of a loved one, I just want to say that I'm sorry. Dealing with the death of a family member or a loved one is really hard, and it's not easy. And I understand how hard it is. I've been through it myself. The hardest thing about it is uncertainty. And so find information, find whatever you can. And if you need help, definitely call a professional, because the best estate attorneys have been through this hundreds or even thousands of times, and they can help. If you found this video helpful, don't forget to like, subscribe, and share it with someone who you feel needs to hear this. Your legacy matters. Let's protect it together. Thanks for watching.